So friends, on fraud there are a number of citations given here, and further there is an important citation, Daniels versus Daniels, 1977, New LJ 938. In this case, the plaintiffs were minority shareholders of a company, brought an action against two directors and the company, alleging that the company, on the instructions of the directors, two directors who were majority shareholders, sold the company's land to one of the directors who was wife of the other for 4,250 pounds, and it was undervalued, and the same land was sold by her later on for 1,20,000 pounds. The court said this is wrong. This is nothing but breach of duty. And then the court said, even though no fraud alleged, there was breach of duty by directors and the majority shareholders, in fact, are concerned, they acted to the detriment of the company and benefit of the, in fact, to the benefit of the directors. So the minority can maintain a suit, and minority was permitted to go ahead in this particular matter. So this is one of the most important judgments. Now, friends, we will come to the circumstances under the statute, where under the Companies Act, the in fact actions of majority ultimately will affect minorities' rights. Then the courts will, or the NCLT now will interfere. One is acts requiring special notice, where an act is required to be passed by special resolution and it is passed by ordinary resolution, then the courts can interfere. One is Daksh Dakeswari Cotton Mills Limited versus Neel Kamal Chakravarti, AIR 1937, Calcutta High Court 645, where the Calcutta High Court held that where voting on a resolution takes place by show of hands, a declaration by the chairman that resolution has or has not been passed inconclusive only if he does not find by his declaration the figures for or against the resolution. Then the chairman finds the figures erroneously erroneously in point of law holds that resolution has been duly passed. The resolution cannot be said to have been passed according to the law, therefore it's liable to be set aside. In the same way, there is an English case of Bailey versus Oriental Telephone and Electronic Company. And then, friends, further, there is another case under statute, infringement of individual membership rights of shareholders, where the individual rights are affected. For example, the liability of the members is increased. Right to use his voting right is violated. The right to object compulsory transfer of shares. Right to object the appointment of two or more directors by a single resolution. Right to insist for notice of not less than 21 days for annual general meeting illegally. Once again, I request you, please mute your mics. It is affecting the YouTube and it will be disadvantageous for you. It is at your own detriment. In online programs, a kind of discipline is required. Otherwise, it will be for your disadvantage. Then the right to apply to the board was affected. That is NCLT is affected. So friends, there are umpteen number of instances under this particular caption where the shareholders are prevented from exercising their individual membership rights. So in that event, even a single shareholder can proceed off. In Joseph versus Jose, Joseph versus Jose. In fact, this is 1964, 1 Company Law Journal 105. The Kerala High Court held that individual membership right implies that the individual shareholders can insist on strict observance of legal rules, statutory provisions, and the provisions in the memorandum and articles which cannot be waived by mere majority of shareholders. Then Cross versus Lloyd Property Limited, 1965 VR 232, equal, and another case, Bearer Trading Company versus G.G. Dikshit, 1972 42 company cases, Bombay. And then in this particular case, the director refused to retire in accordance with the articles and wrongfully continued in office. The plaintiff shareholder was entitled to bring an action against such directors. Then Madras High Court, another judgment said in Nagappa Chettiar versus Madras Race Club, 1949 1 MLJ 662. It ruled that the shareholder is entitled to enforce his rights, individual rights against the company, such as the right to vote, the right to have his vote recorded, and the right to contest for directorship of a company. Similarly, another statutory impediment is that the wrongdoers are under control. If the wrongdoers are under the control, then also the majority rule will not apply. The principle, Glass versus Atkin, I already discussed. Then, friends, another thing is Wallersteiner versus Moyer. And then these are all the cases where it was held that wrongdoers are in control, then they would not be permitted to proceed further. Then the most important thing, oppression and mismanagement, where there is an alleged oppression and mismanagement of affairs of the company, then the majority rule principle will not apply. Lord Cooper in Elder versus Elder and Western Limited, 1952, cited. It was cited in Shanti Prasad Jain versus Kalinga Tubes, 1965 1 Company Law Journal, page 193, Supreme Court. The essence of the matter seems to be that the conduct complained of should be at the lowest involve a visible departure from the standards of fair dealing on which every shareholder who entrusts his money to the company is entitled to rely. Same is the case with Scottish Wholesale Society versus Mayor. The complaining shareholder must be under a burden which is unjust or harsh and tyrannical. Now another case, Re H.R. Harmer Lord. A persistent cause of unjust conduct may be shown for mismanagement. In the same way, unreasonable refusal to accept a transfer also is a matter of oppression and mismanagement. Then, friends, Rajahmundry Electric Supply Corporation versus A. Nageswara, AR 1956, Volume 5, 213, where the vice chairman in this case was grossly put on mismanagement of affairs on the company, alleged, and had drawn, considerable amounts for his personal purpose, and large amounts fell due to government for charges to be paid for supply of electricity and machinery went in state of disrepair. So the shareholders, in fact, brought an action. Then the court held that sufficient evidence of mismanagement, and court appointed two administrators to look into the matter and then manage the affairs of the company. So today, the oppression and mismanagement is concerned, the provisions are laid under sections 421 to, in fact, 426. 421 to, 241 to 246. In fact, These are all very important provisions under the Companies Act 241 to 246, which deal with the subject of oppression and mismanagement. Under this oppression mismanagement, if the elements of oppression and mismanagement are proved, then the courts can, then now the National Complaint Tribunal can intervene, and then it can then give appropriate reliefs and take redressal measures to rectify the oppression and mismanagement. Actually, this is a independent subject. Prevention of oppression and mismanagement, I will deal with in a different topic. But this much is enough to be written as exceptions to the doctrine of first versus principle of first versus or whatever. So based on this now, I have given volume part 1, part 2, today part 3 and part 4, because there is a break, I continued. So part 3 and part 4. 4 parts for this principle of majority rule and minority rights, and then rule of first versus horizontal, along with exceptions thereof, in which the last part under statute is prevention of oppression and mismanagement, and we will deal with that particular subject matter separately in our forthcoming lectures. Hopeful to meet you again tomorrow if possible. Otherwise, I will send material as usual. Anyway, we will continue until the syllabus is complete. We'll meet again. So thank you very much then. And then friends, goodbye. We'll meet again. And then thank you very much.
Thank you, sir.